Capacity of parties, as I said, it is the eligibility of the individuals who are going to enter a contract. Before making a contract, all the terms and conditions must be disclosed. Means, say for an example, if there is any default in the cell phone, that must be disclosed. Mutual agreement. So it is a mutual agreement which is going to happen by the consideration of both the parties. Contingent means there are few agreements which depends upon the occurrence and non-occurrence of the things. Hello everybody, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First State College, MYSURU, the Temple of Excellence. In today's session, we are going with Session 2 of Unit 1 of a subject Business Law, that is for 6th semester BBA students. Moving forward, this is agenda of today's session. These are the topics we need to cover: contractual capacity, free consent, classification of contract. These are the 3 topics we need to cover in today's session. Capacity of parties. So when it comes in terms of the capacity of parties, as I said, it is the eligibility of the individuals who are going to enter a contract. Okay, so as we know, the contract is going to happen between 2 individual parties, okay, or more than 2 individual parties. Okay, so if it is going to happen between 2 parties, means both the parties must be eligible to enter a contract. They must consist of eligibility criteria. What will be the criteria that we are going to learn further? Okay. Contractual capacity refers to the legal capacity of a parties to enter into a valid contract. It is a legal capacity of a parties to enter a valid contract. So if there is no capacity, it cannot become a valid contract. It may become a voidable contract or void contract. According to the Indian Contract Act 1872, a person must possess certain qualities to have a contractual capacity. Okay, so there must be some elements in the both end of a parties to consider a contract as a valid contract. Okay, which are all the elements? There must be, okay, age of majority. Okay, so if a person want to enter a contract, okay, so whether he is a promiser or a promisee, okay, they must be 18 plus of age. Okay, so they must be what? 18 plus of age. Okay, so if he or she is a minor, what happens? So it will become a void contract. Sound minded. Okay, so he or she should be sound minded. We are not supposed to make a contract with the people who is unsound minded. Okay, because they could not able to understand the terms and conditions of a contract. Next one is legal competency. Here, he or she who is going to enter the contract, they should not be disqualified by the law. Say for an example, we are not supposed to make a contract with a insolvent person. We are not supposed to make a contract from the people from the enemy countries which had fought a war against our country. Okay, so we are not supposed to make a contract with the minors also. So no, so there are various conditions, okay, so which is formulated by the law. We are not supposed to make a contract. Okay, so free consent. To consider a valid contract, there must be free consent from the end of both the parties, promisor and promisee. There should no coercion, there must not be fraudulent purpose, and nor there must be a undue influence. So then it will consider as a valid contract. If there is a undue influence, so we cannot consider that kind of a contract as a valid contract. Lawful object. The objective of the contract must be lawful and it must be enforceable by law. Say for an example, whatever the contract that they are going to make, it must be lawful. So if it is not lawful, it may become a invalid contract or a void contract. Okay, say for an example, Mr. A can make a contract to buy or sell a car or a bike or any kind of vehicle, or to do any kind of the activity by Mr. B. He cannot make an agreement with Mr. B saying that he should bring ahead of Mr. C. Okay, so because it is illegal in nature, hence it is not enforceable by law. It will become a void contract. It is not a valid contract. Capacity of a contract. Capacity of a contract means the people, okay, so who are entering the contract, they must capable of understanding the terms and conditions of a contract, and also they are capable of understanding the consequences, and they should be competent to understand all the things that is stated by the Indian Contract Act according to section 11. Moving forward, next concept is free consent. Okay, so whatever the contract that is going to happen between two parties, they must feel very comfortable, they must feel happy to make a contract. So we are not supposed to scare them, right? We are not supposed to do undue influence. Okay, we are not supposed to utilize or misuse for the fraudulent purpose as well. Okay, so we are not supposed to utilize the contract for the fraudulent purpose. Okay, so there must be what? Free consent with the end of both the parties. Okay, so whether it is a promiser and a promisee. Okay, so what is this free consent is about? Free consent is a fundamental principle of Indian contract law. Okay, so it is a fundamental principle of Indian contract law. If there is no free consent, it will become a voidable contract. As ensured in section 13 of the Indian Contract Act 1872, it refers to the agreement or a willingness of all parties to a contract to do something or same sense or harmony. Okay, so say for an example, here we shall consider she is a Miss A, Mrs. B. Okay, so Miss A is going to make a contract with Mrs. B. Okay, the contract is Miss A is going to sell her cell phone to Mrs. B. Okay, so based on certain considerations. Okay, so to facilitate the cell phone or to provide the cell phone, Miss A should feel very good and happy. Okay, and Mrs. B also, she should feel very happy to buy or purchase a cell phone of Miss A. Okay, so what happens? It will become a valid contract. So he should not go with undue influence. There must be no coercion. Yes or no? So she must not utilize. Okay, so for the fraudulent purpose as well. Okay, so whatever the terms and conditions will be discussed earlier itself. Okay, so it can become a valid contract. Means there must be free consent with the end of both the parties, whether it is a party A or party B. In other words, free consent means that all parties have mutually agreed up with the same thing without coercion. Okay, so they had agreed with the same thing. Let me consider an example. Okay, so Miss A had offered Apple iPhone to Miss B. Okay, so she is very happy to offer a Apple iPhone, and also she is very happy to purchase Apple iPhone by paying 10,000 rupees. Okay, so there should not be coercion. She should not scare Mrs. B saying that if you won't buy this by paying 10,000 rupees, I am going to fire you. I am going to encounter you. Okay, so she should not scare her and she should not sell her product. Okay, so there should not be undue influence. Okay, so Miss A should not do any kind of undue influence to scare Miss B. And fraud means, as I said, before making a contract, all the terms and conditions must be disclosed. Means, say for an example, if there is any default in the cell phone, that must be disclosed. Okay, so if not, it will become a fraud. Okay, so it cannot become a valid contract. If there is any problem with the mobile or the product or the thing, that must be disclosed by the promiser to the promisee. There should not be misrepresentation. She should not misguide her saying that this condition is very good. Okay, so she should not misguide the Miss B. Okay, so regarding the condition of a cell phone, regarding the termination of the contract, or regarding the price of the contract, yes or no? So she should be true and fair, and she must be very transparent in terms of a contract, because it should be considered as a valid contract if it is not. Okay, if the terms and conditions are not being disclosed, so Miss B have a complete right to sue against Miss A. Okay, mistake. So there should no mistake while happening the contract. So what happens? So most of the times, so Miss A may forget certain things to disclose with Miss B. Okay, Miss B may forget to disclose certain things while entering the contract, and after that they get realized. Okay, so these things should not happen in a contract. Okay, this should not be mistake that is done by the end of both the parties. Whatever the things that I said, okay, it is applicable for both the parties, whether it come in terms of coercion. Okay, so she should not scare her or she should not scare her. And again, undue influence. So there should not be undue influence forcing to enter a contract from the end of both A or B. Okay, fraud and misrepresentation. So these things must not be utilized for the fraudulent purpose, and there should not be misrepresentation, means they are not supposed to misguide the people. Factors of free consent. So there are various factors that will be considered as a element for the free consent absent of coercion. Okay, so there should be no coercion in the contract. So he or she should not scare, okay, to enter a contract. Okay, there should not be coercion. If there is a coercion, so it may become a void contract. Absence of undue influence. So there should not be undue influence. What is this undue influence? So they may take the advantage of their position to scare somebody. Okay, so due to my position, because I am so and so, I am in a higher position, higher designation. Okay, so I cannot scare a people who is in the inferior position or the designation, saying that if you won't make a contract with me, I am going to do that, this and all. Okay, so they are not supposed to misuse the position and scare the person to enter a contract. And again, mutual agreement. So it is a mutual agreement which is going to happen by the consideration of both the parties. Okay, so both the parties should free consent to enter a contract. Voluntary act. So there is no public invitation that is given to the parties. It is a voluntary act. If they are willing to sell their product, they can sell. If they are willing to enter the contract, they can enter. Okay, if they are going to propose the contract to some other person, they can propose. If they are interested, they can enter into the contract. If they are not interested, they may not enter the contract. It is a voluntary act. So nobody is going to force you to enter a contract. So if anybody force you to enter a contract, okay, so it will become a void contract. It is not enforceable under the Indian Contract Act 1872. No mistake or misrepresentation. So as I said, so there should be no mistake that is going to happen in a contract, because the terms and conditions will be disclosed earlier itself before entering the concept, and there should not be misrepresentation. They are not supposed to misguide regarding the quality of the product, regarding the durability of the product, or regarding the terms and conditions of the agreement, okay, which is going to happen regarding the contract. Here, as I said, free consent is a essential element in a contract. If there is no free consent with the end of both the parties, or it may be in terms of one party, okay, so the contract cannot be a valid contract. So when it comes in terms of a pressure and intimation, okay, so nobody is supposed to make force, nobody is supposed to put a pressure to enter into a contract. Okay, so if they scare them, if they put a pressure, okay, so it will become a void contract. It cannot become a valid contract. Equal rights in decision making. So both the parties, whether it is a promisor or a promisee, they do have a equal right to take a decision in a contract. So based on their convenience, that they are going to take a decision and enter a contract. Not only taking the decision and entering the contract, but they are supposed to perform. Okay, so the terms and conditions that had been specified before entering the contract. No fiduciary relationship. So free consent does not involve a fiduciary relationship, where a party have a duty of care and loyalty towards another party. This cannot be happen according to the Indian Contract Act. Moving forward, classification of contract. Based on the characteristic of a contract, the contract had been classified into various categories. According to Section 2, subsection H of the Indian Contract Act 1872, a contract is defined as an agreement enforceable by law. Okay, so there is a presence of two elements. Number one, it is a agreement, and number two, it is a enforceability. So as I had disclosed in the first session, okay, so there must be two elements to consider a contract as a valid contract. So A plus E, okay, A plus E, that is nothing but agreement and enforceability. Okay, so this agreement and enforceability is considered as a essential element of a contract. Okay, it is one of the essential element of a valid contract. Okay, so if there is no presence of one of the element, either agreement or the enforceability, it may become a void contract. Every promise and every set of promises formulating the consideration for each parties, that we call it as a agreement. So as I explained in the previous session, okay, so there may be a social obligation for an agreement, or there may be a legal obligation or the lawful obligation in terms of a agreement. So what is this agreement means? Offer plus acceptance. Okay, so one is going to offer something, so another one is going to accept the offer that is made by person A. Okay, so offer plus acceptance give rise to the agreement. Enforceable by law. The agreement must be capable of being enforced by the contract of law. Okay, so whatever the things that they are going to do, okay, that must be legal in nature and it must be enforceable by law, means Indian law. Classification of contract, as I said, based on the nature, it is classified into various categories. Number one, a valid contract. Okay, a valid contract means there should be no coercion, there should be lawful consideration. Okay, there should not be a undue influence. Okay, so he should be a sound-minded people. Okay, so here there are certain criteria that we had learned early itself, okay, to consider a valid contract. This valid contract is enforceable by law. Okay, so it is a lawful contract that we call. Okay, a void contract. So a void contract, a contract which is made with the minor, a contract that may be made with the coercion. Okay, so by the contract that may be made with the undue influence, a contract made with the insolvent person, so that will become a void contract. So according to Indian Contract Act, we are not supposed to scare them to enter into a contract. Okay, so there must be no coercion, there must be no undue influence, there must be no fraudulent purpose, right? So according to Indian Contract Act, so if there is any undue influence or if there is any coercion, so that kind of a contract we call it as a voidable contract or a invalid contract. Say for an example, okay, so Mr. A and Mr. B, okay, so Mr. A want Mr. B to enter into a contract. Okay, so what Mr. A do? So he's going to utilize his position and he's going to scare Mr. B to enter into a contract. Okay, so after scaring Mr. B, so he gets scared and he enter into a contract. But at the end of the time, Mr. B go to a court. Okay, so he go to a forum and he claimed against Mr. A, saying that he scared me, so I signed the contract. Then that contract is going to become a voidable contract. Okay, according to the law. Okay, so if he scare him and get signature, or he forcefully make him to enter into a contract, that contract will become a voidable contract and it is completely invalid according to the Indian Contract Act 1872. Express contracts. Okay, express contract means all the terms and conditions of a valid contract must be expressed in terms of both the parties, whether it is a promisor, whether it is a promisee. Okay, so all the things must be disclosed in a written format or a oral format. Orally or written format, it must be disclosed. Implied contracts. These kinds of contracts are the unwritten agreements where the terms and conditions will be followed by both the parties, but the terms and conditions are not at all mentioned in a written format. That kind of contract we call it as a implied contract. I will give you best example. A patient get admitted in a hospital. Okay, so he will get all the kind of treatment for a week. Okay, after taking a treatment only, he is going to pay the bill and he is going to come out. He is going to discharge by the hospital. Okay, so what happened? So Mr. A, when he visit the hospital, every day, not the doctor nor the hospital people, they are going to ask him or approach him to pay the bill. Okay, so it is agreed saying that he is going to pay the bills of the hospitals before he get discharged. Okay, so only after paying the bill only he will going to discharge from the hospital. That kind of the agreement between the patient and the hospital. Okay, that we call it as a implied contract, because there is no any kind of a written agreement that is going to happen between both the parties, but he have to pay based on the circumstances. Okay, the bills of the hospital. Okay, He have to settle on all the bills and he have to get discharged. Contingent contract. Contingent means there are few agreements which depends upon the occurrence and non-occurrence of the things. Okay, say for an example, health insurance. Okay, so and life insurance also. Okay, so what happens if I take the health insurance? Okay, it does not mean that I am going to get admitted in the hospital. Okay, so I may get admitted, I may not get admitted, but it is a assurance that is given by the insurance company. So what happens, I get admitted also, I am supposed to pay the premium. I won't get admitted also, I am supposed to pay the annual premium. Okay, so if I get admitted to the hospital, so what happens, the insurance company, it is going to bear the expenses. That is the contingent contract. So it totally depends upon the situation and the circumstances. So possibility of occurrence, but there is no assurance. Okay, wagering agreements. Okay, so there are certain agreements where the people are not at all intended to enter into a contract, but they are going to enter into a contract. Okay, so there may be the absence of a free consent. Okay, so and most of them they are interested and most of them they are not interested. They may gain or they may lose. Such a kind of a agreement, we call it as a wagering agreement. Best example is bets in a horse course. So IPL betting. Okay, so this kind of the betting, that we call it as a wagering agreements. In the next session, we are going with the discharge of contract, breach of contract, and also remedies for breach of contract under section 73 and 75 of Indian Contract Act. Thank you.